very, very much. I'm very, very honored to speak to everybody. The work of the society is extraordinary and created a tremendous resource for not only genealogists but historians across a multiplicity of subjects relating to the Sephardim. So there's a lot to get through this evening, so I'm just going to press on. And hopefully we'll cover the material that I've prepared tonight. So what I'm going to do, as Ton has outlined, is to look at three main things: the halakhic framework for a Jewish judicial space, the Ascamot, which can be understood as the way in which the community's vision for a justice space was articulated. And also, I'm going to look at the exercise of practical justice in the community through the Mahamad's tribunal, which we can understand through these marvelous books that came to light, certainly to the academic community, in 2007, when the late Edgar Samuel published an article called "The Mahamad as an Arbitration Court" in the journal Jewish Historical Studies. Two of these books are already on Transcribus, and I've given you the link there. So let's go straight in. There's a concept in halakha that Jews are prohibited from resolving their disputes other than in front of Jewish court. This is in the Talmud, in Tractate Gittin 88b, where it says, Rabbi Tarfon used to say, in any place where we find agoriot, non-Jewish courts, even though their laws are the same as Israel's laws, you're not permitted to resort to them, since it says these are the laws that you shall set before them, and not before hedyotot. So this is the text that we need to unpack in order to understand what's going on. The historical background is that we're post destruction of the Second Temple, and we've seen the shattering of the court structure pre the destruction, and the loss of coercive power for the community. And so the claim for exclusive jurisdiction of disputes between Jews is now contested because there are other courts. And as this text shows us, it was a possibility for Jews to litigate in other courts and for the law of those courts to be the same as Israel's laws, as Jewish law. And even, as the conversation in the Talmud would show you, for Jewish law to be applied. But what the rabbis are saying is, no, we don't want you to do this. And they do that by referencing a text from Exodus 21:1, and to hone in on these words before them and to ask, what does before them mean? To them, what before them means is, we're going to have this every time, before them has a complex meaning. It clearly doesn't mean non-Jews. So what does it mean in relation to Jews? The clue is in this word hedyotot. What the rabbis are debating is a question of who has judicial authority, who are to be these judges, who are to take forward the judging of disputes between Jews. What is broken here is what was called smicha. Now, I guess most of us have heard that word because a rabbi serving in our communities, whichever denomination it is, will have smicha. They will have passed a test which allows them to practice as a rabbi. But what we're talking about here is something completely different. We're talking about formal smicha, a ritual of handing down from one judge to another by the laying on of hands, this concept of having judicial authority. And that's what's gotten broken. So the question is, who carries it on? And to short circuit all of the conversation, what happened in that we see in the Talmud, in the discussions, is that we have two types of people. We have experts in halakha, the rabbis, who have authority by the chain of transmission of their expertise. One person teaching another person. That is effectively a modern concept. But there's also a question of, can this word hedyotot also encompass somebody completely different? That is layman. And why layman? Because not everybody in a diasporic context had the relevant expertise, halakhic expertise, to be able to judge disputes according to halakha. And we see in the medieval period that there's a concept of the good men of the town who, in order to meet the needs of the hour, run a justice system that doesn't just always encompass halakha, that is really common sense, good sense. And you have the development of hedyotot shel batei din or beit din, a tribunal, a court that is run by lay judges. And that is the concept that we see in early modern London in the Sephardi community. We also need to understand the difference between strict justice and compromise. Peshara is the word that the Talmud uses. Strict justice is something that a court of these expert rabbinical rabbis could potentially decide a case upon. That is, the strict laws of halakha in whatever case it is. And against this is using the concept of peshara as something different to resolve a dispute. A modern beit din will offer to parties the possibility of resolving a case by peshara, by compromise, before the case starts. And this will ring with people who've seen commercial litigation in many places across the world, where you try and settle beforehand. And there are many ways of doing this. Is done outside of the court, not inside the court, by mediation or arbitration. That's a whole story in and of itself, which we don't have time for tonight. But this is what we're going to see in early modern London. And there's just one other halakhic issue I want to highlight in relation to the concept of a Jewish court, and that is that a Jewish court has to have 3 judges. And this we will also see in London. So I also want to highlight for you that there is another side of the coin. And that is that when you are looking at a justice system, a minority justice system, working inside of a majority system, there's the potential for the crossing of jurisdictional boundaries by the litigant using a court that you don't want them to use, or using a law of the land that you don't want them to use. And we see in halakha concepts that develop in order to control the crossing of these boundaries. The first is dina de malchut dina, the law of the kingdom is the law, which is a very ancient concept in halakha, by which the Jewish court itself can enable a foreign law to be applied by Jewish judges in a dispute. And modern courts will do this as well. They will apply a foreign law in certain circumstances. The other way in which they do it is to say, here is my exclusive jurisdiction, and here are parts of my jurisdiction where I'm prepared to countenance the use of another legal system's law. And in halakha speak, that's the difference between mamonah, monetary matters, what we would see as civil law, and isra, matters of pure religion, over which halakha will claim exclusive jurisdiction. And these are things that are very familiar to us. Personal status issues, marriage, divorce, conversion, ritual, kashrut, and also to a large extent inheritance. These are the matters that a modern Beit Din will have as the majority of its case law. There are other problems in a diasporic context for a minority legal system like the halakhic system in the Jewish courts. And that is that it doesn't have absolute coercive power, which any majority court system will have. There are various fixes to this. One I want to mention is one that arises in the Gaonic period in the 9th century in Babylon, now the Persian Empire, where the Gaonim say it's not fair if a claimant will come to us and give us their dispute and say, please, will you adjudicate it? But a defendant refused to submit to our jurisdiction. So we summons this fellow to come to us as the defendant, and he refuses to come. What's the claimant to do? To give up his case? A very common problem, for example, for common issues such as death, where somebody could be shut out of justice. And what's the judges come up with is a way in which they can control the process by which a case can go into another legal system. And they do that by saying to the claimant, you must come to us and submit your case. But if the defendant doesn't cooperate, we will give you permission to sue in non-Jewish courts. So they provide a gateway by which a Jew is permitted to go to a non-Jewish court through the control of the Jewish courts. I just want to mention the issue of internal enforcement because as people who specialize in Sephardim, I'm sure you've seen that across many records of the use of the cherem. The cherem was the weapon of coercion to try and ensure that people complied with the way in which the community was being run, including submission of cases to Jewish courts. There's a whole history of that in the early modern period about the extent to which it retained its true force and whether it was desacralized, but we don't have time for that tonight. But I just mentioned that as something to look out for. And then the other side of that coin is the issue of, can you ask the non-Jewish courts to help in the enforcement of Jewish judgments? And we see that in charters of privilege, which some of the Sephardi communities would have had, where you can ask a foreign court, the court in which your community is living, to assist in the enforcement of a Jewish judgment. But in England, there's none of that because there's no charter of privilege. And equally, there's a very open system of justice where there are no barriers put in the way of Jews to go to English court. So that is the scene setting for our early modern Sephardim in London. I want now to go to the Ascamot of the community and to look at it from the founding of the community to the middle of the 19th century, because those are the overlap periods with the Livrosh. And I want to look at how the procedure that these Ascamot set up, the what, which is what type of disputes are they claiming jurisdiction over, and the why. Can we see an articulation of this halakhic framework? So let's start with Ascamot 25 of the very first Ascamot of the community. And this is where we see the procedure being set up. And subject to, of course, there are differences over the course of the centuries, but not so many as to be, wildly noticeable. What we see is that there was a procedure by which the shamash of the community would summon a prospective defendant to a hearing before the Mahamad. And there was a system by which a failure to respond to the summons would have sanction, although these are unspecified in 1664. And at the beginning, we see that the Mahamad is to be neutral. And by that, I mean that their role was to persuade the parties to arbitrate. They weren't to be the arbitrators. Other people were to be the arbitrators. Although the caveat to that is the parties could appoint the Mahamad as individuals rather as qua Mahamad to be their arbitrators. But Ascamot 25 also had two other important provisions that were to be retained. The first was that subject to submission initially to the Mahamad, there was a control mechanism by which the parties were to be free to seek and defend their rights before whom they may please. If a case failed to settle, or parties couldn't agree to appoint arbitrators. So there was a recognition that it would be unfair to lock people out of any justice because there was somehow a failure in the Jewish judicial space. And the exception provision is that there was always from the start a recognition that if there was an urgent case where delay would be prejudicial, Jewish parties would be entitled to find some other mechanism by which they could settle their case, potentially. Initially, that was only applied in relation to letters of exchange and detention of goods. So it had quite a narrow ambit in the 1664 Ascamot. But by the late 18th century, we see this increasing in ambit. Letters of exchange are still there, but now detention of goods is gone, and other causes is the wording that is being used. And by the middle of the 19th century, it's very vague, any case. So if you think about it conceptually, there is the potential for any member of the community to simply argue, oh, my case is very urgent, and therefore that is my reason for not involving the Mahamad at all, but to go straight to some other mechanism to resolve their case, be it a formal arbitration outside of the Mahamad, a mediation outside of the Mahamad, or actually to go to the English courts. I'm going to give you now, if it'll stay on the screen, two cases of an urgency example. The first is an example from Livro de 2, which is on Transcribus. So if you want to go and look at it, note page 87, and you can look at it in more detail. And this is a case where it's ex post facto. Somebody who's a tenant has disappeared without paying their rent, and the landlord is applying for leave to arrest the tenant. And he comes to the Mahamad, and the Mahamad gives leave. Now, for him to go to take whatever English process he wants to try and, make sure the guy doesn't twist the jurisdiction or something like that. Now, he doesn't need to do this, as we've seen, because he could have just done it, gone against this fellow without even asking for permission, but he has in fact asked for permission. In the second case, we have the opposite. We have the executors of a will who have arrested somebody, and the person they have arrested have complained to the Mahamad and said, oh, he did that without license from you. That's wrong. And what the Mahamad then say, as you will see, is actually no, the Ascamot gives permission for him to be able to do that. So that's all fine. Okay, so let's look at the major change that happens in the 18th century, or the late 17th century and 18th century, is we have a dropping of this neutrality. And what we see is that the Mahamad now, by the Ascamot, are intended to have an active role in the resolution of disputes. And I've given you some wording here from 1677 and 1694, saying to use all possible diligences to settle disputes. And if the settlement can't happen before them, then they will appoint arbitration judges. So we have a two-stage process now. And I've just pointed out here in passing that we see in the early 18th century that the articulation in a very interesting way that you can't have a single parnas who decides a case. That is to say, they are sticking by the three-judge rule. And you'll see through the names of the Mahamad panel that there are always three. If we go into the late 18th century now, there's a different way of articulating this active role, endeavor to reconcile the parties to a solution that reflects reason and justice, or to get the parties to arbitrate their disputes. But you need to look at two clauses now. One is a general duty in the Ascamot and a separate procedure Ascamot. And that tracks again into the 19th century, where we have very similar wording. And we also have a procedure provision. But by the time we get to the middle of the 19th century, we've gone back to the very beginning. We've gone back to a single Ascamot as we had in 1664 and in the late 17th century, although it still retains its two-stage process, by which I mean you have the Mahamad being active mediators before them in the tribunal, hearing the litigants, or if they can't settle, trying to see whether they can have a separate process outside of the Mahamad by way of assessment or arbitration. And we still see tracked throughout this permission to sue requirement and an urgency requirement, as we saw before. So let's turn now to the disputes themselves. We again have the same overarching development. We started with something narrow in the 1664 Ascamot, which referred to all affairs of business, being the types of disputes over which the Mahamad claims jurisdiction. And I would argue that that kind of fits with who these people were in 1664. They were the former conversos who had come out, so to speak, and had formed the initial community in Free Church Lane, and then in later on in 1701 in Bevis Marks. And they were these merchant traders who were either trading in London or who were doing commercial trade, across the seas commercial trade. In 1664, we also see that crime is excluded. And there's a specific Ascamot 37 for that. And that also fits with these people. They want to keep the peace. You might know about Charles II's Declaration of Indulgence. That he will tolerate the community who peaceably live in London. And they don't want to be associated with anyone who has committed a crime. But we see by the end of the 17th century that there is a hugely extended jurisdiction over all doubts and disagreements. And although the wording changes at the end of the 18th century, we are still in that world of the Mahamad claiming jurisdiction over everything that might possibly arise within the community. And in the 18th century, we also see that there is a claim to a small amount of what I would argue is a minor crime. And what they're looking at and what they're worried about is people getting into fights within the synagogue, which really did happen, or in its immediate environs. And we need to understand that the geography of the community is that what was called La Fabrica, the place where many of the people who were in receipt of tzedakah, many of the working poor, the indigent, were living in accommodation provided by the community, and they were getting into a lot of fight. So they are not wanting that stuff to go to the local justices of the peace. They're saying, we want you to come to us. But by the middle of the 19th century, those minor criminal matters have gone, which is also understandable for a host of reasons, which we won't have time to get into. What were the types of disputes then? Well, anything and everything, as this claim to jurisdiction shows you. And you will find an amazing array of information in the 6 books of the Livro. Debts, family disputes, inheritance disputes, employment disputes, these quarrels, violence, physical violence. Just to highlight a few things on the slide, there's a lot going on. Debt, trade bills haven't been paid, there are loan notes, there's rent that's unpaid, they're quarreling about their trading accounts, there's money lending. Employment within community organizations, private employment, apprenticeships, quarrels between families, between neighbors. I just want to highlight family disputes for you because I want to explain that although we see these family disputes and we see separation between husband and wife, we see their financial arrangements, we see their arguments, their violence, you need to understand as well that this did not mean that the Mahamad's tribunal had jurisdiction over everything. As I said before, when we're looking at halakha, halakha breaks down between mamonah, monetary matters, and isura, religious matters. Much of the work in relation to family disputes remained always the province of the Beit Din of the Sephardi community, for which we have evidence from the early 18th century that they certainly existed and were active. And so what was happening in these books, if you read them together with the minutes of the Mahamad, is that the Mahamad retained administrative control over all types of disputes. If there was a marriage or divorce issue, they would remit the case to the Beit Din, and the Beit Din would then decide the case in the Beit Din, and they would then report back to the Mahamad so that they retained overall administrative control. So watch out for these family disputes, and you cannot assume that if something is mentioned, that it is the totality of a dispute, because there might be something that you need to cross-check in the minute of the Mahamad to see whether the batei was involved. Just to look at motivations now. So I've made the claim that there's a halakhic injunction to avoid using non-Jewish courts. And we see that through the control mechanism of the Ascamot. But we also get little other clues. No clue in 1664, but the clue starts to track into the Ascamot from the late 17th century onwards, where we see that there's a reference to Jews not using the outside courts because it is scandalous and it's a profanation of God's name. And this phraseology, profanation of God's name, is a reference to the Shulchan Aruch, and backwards from the Shulchan Aruch to the Rambam, Maimonides, and to Rashi, that the halakhic framework is always troubled by how do we get buy-in from people who understand that there's also an outside legal system operating here, which they might use. And it develops a concept that it's a sin, it's a religious sin to be using outside courts. And that is the reference to profanation of God's name. But it doesn't last, because by the 18th century, we are simply left with this issue of scandal, which by then the wording that is being used is odium and odious, although it still says avoid resorting to public courts of justice. And by the late 19th century, it's completely silent. So I think that we can see that there were religious motivations, but by the middle of the 19th century, there is the concept of private justice in the Jewish judicial space versus public justice in the courts of the land. So let's jump into these books for the next 15 minutes. There are 6 folio books which keep a continuous record from 1721 to 1868, though there is a gap between 1829 and 1837, an unexplained gap, which I, in all my research, couldn't answer why there was a gap. Maybe there's a 7th book hiding somewhere for that period. That's my suspicion, that there was a 7th book. It's been either completely lost or it is somewhere, probably in Laudertown Road, David. That was our previous off-air conversations. The originals are in the London Archive. It used to be called the London Metropolitan Archive. And you need permission from the Spanish and Portuguese communities archivist to look at the originals. And I've given you the phone number if you really want to do that. Whoops. But thankfully, they're now online. They're online at the National Library of Israel. And I've given you a search term that you can use in order to find them easily. And they will eventually, some of them at least, be online on Transcribers. So they are so much easier to read with the software that Transcribers has. The first 2 are there, and I recommend you just have a browse. Okay, and let's jump on to this tribunal. What was it? Panel of 3 from the Mahamad's committee, and some of the Livrush will give you a panel where the person writing the record will actually write out the names of the panel. So it gives us clues about the justice system, but for anyone who's doing genealogical research, well, there are loads and loads of these names, and it's a wonderful resource, apart from the litigants' names, of course. It met in the synagogue building, probably in the Mahamad's chamber. It probably took place, the tribunal, after the main Mahamad's administrative meeting. If you track the dates between different administrative records, its meeting frequency varied across the Livrush. But by the 19th century, it's meeting on Rosh Chodesh, so once a month, but it's can be much more frequent in the earlier records. Its dating conventions differ across the sects. Sometimes it uses only a Jewish calendar. Sometimes it uses the Jewish calendar and the Gregorian calendar as well. And they use Rosh Chodesh as a date of meeting for themselves as a tribunal, but also as a payment date. So watch out for that. Oops. Who is keeping the records? Sometimes, particularly in the earlier documents, you'll have a signature from the gabbai, which signals that it's the gabbai who's keeping the record. And the only other thing to mention, which is absolutely vital, is that it's a free service. So unlike the English courts where you'd have to pay for various aspects of procedure, this is completely free. And here I've just given you one example of that has a Jewish date, an English date, and has the 3 panel members and their names. Language. In Portuguese until 1819, when all of the administrative records by resolution of the Mahamad are swapped into English. There's occasional English. In Livro 2, there's fair amount of disputes which are in English, which you can just go immediately now onto Transcribus and read. And then there's fascinating terminology, at least to me, of that signal what the nature of the Mahamad's role might have been in the room. What were they actually doing? Mediation, arbitration, adjudication, different words. You can see it in English, you can see it in Portuguese. Settle, adjust, order, resolve, recommend. And in my research, I make an argument that those words signal type of a internal process. Common features, brief summaries of the disputes, sometimes extraordinarily brief, and sometimes in the latest, in the 6th, non-existent. Just the names of the parties. You know, you can see the virtual disappearance of what was going on in the room. The names of the parties, settlement terms, if there's money, payment dates. So keep a lookout for all of those things. Who are the litigants? The Yehidim, but a range of them. One of the other wonderful academics who studied the Livrush from a sociological point of view, Alex Kerner, has an argument that the whole point of the Mahamad's tribunal was as a tribunal for the poor. Now, I disagree on various grounds, but it's a really interesting argument. And to be fair, the majority, certainly in the later years, are the poor. But you do see the wealthy elites, and you do see rabbis, teachers. You see women as claimants. Now, that's an interesting issue in relation to English law, which I don't have time to go into, but if you're interested, ask me a question. We see Tedescos, that you'll know is the name that they use for the Ashkenazim. And there are big issues about, can they really be claimants? can they achieve a resolution to their dispute? Certainly until there is the acceptance of intermarriage and the increasingly close relationship between Sephardim and Ashkenazim, that is an interesting issue to debate. And then occasionally we see even the name of non-Jews. How else can you have a look at the Livrosh? I've mentioned Alex Kerner, who's really has a rich study of the Livrosh from a sociological, historical perspective. But any economic historians out there or accountants, wonderful material to have a look at, for example, the economy of the community. There's reference to the Maasim Tovim, who were a subscription charity for the poor, who were giving small business loans, one-off tzedakah payments. It records payment schedules, the way they redirected tzedakah payments to offset debts. There's mention of loan guarantors, giving all sorts of interesting information about the economy. We see family and neighbor interconnected indebtedness. You know, that was money just being swished around here. Very interesting. Somebody who wants to look at landlord and tenant, housing issues, lots of material there. If you want to examine what sort of businesses were operating in the community, there's also information that you can get from the Livrosh. And I've just given you here on the screen, it's probably too small, but again, page 17, if you want to look in more detail, of a case where we have a dispute about meat. It gives you the amount, so you can have a look about how much were people spending. Was this a butcher? It mentions a father and his son-in-law. His son-in-law has a loan from the Maasim Tovim, and his son-in-law is also creditor, who, if we look at the next screen, has debts owed to him by relations. And then you can look at the amounts that is being offered. So just a very one small dispute can give you a whole wealth of information about the community. I'm going to end with this. We're coming to the end. I've talked about this control mechanism, the permission system. And this is vital to see in the Livrosh, and we see it across the whole of these 6 books. In Portuguese, the words you need to look for is deu licença para ir à lei, and it's sometimes da terra in the land, gave them license to go to the law of the land. That is the operation of the control mechanism. Someone has come to the Mahamad to ask for permission, or alternatively, in some of these disputes, in many of these disputes, has failed to come to ask, and you have the person who was the defendant complaining to the Mahamad. So look out for these things. Other things to look for in relation to the permission system that show you the crossover into the English legal system are English legal process. Look out for bills, writs, summons, warrants. That are all litigation process documents in the 18th century. And then look out for coercion, arrest, bail, prison. And that'll show you that somebody has taken action against a defendant in the English legal system, and there's a complaint to the Mahamad that that has in fact happened. So it gives you a clue, if you wanted to look at English legal records, about where to look. And I'll just mention one of the courts that is very, very important, given that so many of the disputes are debt disputes, and that is the Court of Requests. The Court of Requests is a small debts court run by lay commissioners. It's ubiquitous in England at the time, in the 18th century. It only comes to an end in the 19th century. And we see the forum shopping by litigants, both using the Mahamad's tribunal and also using the courts of request to try and recover debts. I'm going to leave this on the screen. Why did the Livro come to an end in 1868? There's a plethora of potential reasons. The Mahamad in their minutes don't articulate a reason which would give us a clue. It's a question of thinking about what was happening in the community generally, what was happening. Whoops, why is that gone? Don't know. Let's just go to the end. Is there a way I can freeze this? And then there are also issues that are happening in the English legal system itself, which I argue had a profound impact on the conceptualization of lay justice as a valid form of justice in the mid to late 19th century. And I think that there's a very strong argument that that's what really does for it. It's the combination of these things brings lay justice to an end. And we see towards the end of the 19th century something that we recognize as a modern beit din. They are the only form of Jewish justice that we really know about these days. And they are these halakhically qualified dayanim. They have the full panoply of cases before them. Whether it's a civil case or purely religious case, they're the people who are judging the community. And of course, it's still there, the Sephardi beit din. So that's it. Over to you for any questions.
Thank you very much. That was absolutely excellent. Could you close your
Yes, stop sharing.
please? Yeah, thank you.
Yeah.
Thank you very much. That was really excellent, and it's great to see that already the work of the A Nação Hebraica project is being used. Can I first of all just make an observation that you quoted some sociological research about the most of the cases involving the poor.
Yes.
I would assume that's kind of self-explanatory in that a large number of the poor are receiving sort of handouts, tzedakah, from the community, and if you're seeking to get paid, I think in one of the examples you were showing that they were saying to take the money out of Mendoza's tzedakah. That's the obvious way of getting your money rather than going to the
Yes.
civil courts. I would
Yes. I
guess.
mean, one of the arguments that I make is that, okay, let me just go back a step. The historical debate in relation to the Livrush and what it shows us about this form of justice um, is does Mahamad set this up simply because it's responding to what it sees in the English legal system and it copies it in? So you could look at the courts of request and they say, oh, this is a great idea. Why don't we have that for ourselves? And they do it internally. Or you could do what I have done, which is to say, no, this sort of form of justice has incredibly ancient, long roots into halakha. And it also, and I haven't dealt with this at all, can be seen in the records of Western Iberian Sephardim in many different places. Okay. And I say that as a preface to say that it makes sense for somebody like the poor not to use the English courts. Firstly, potentially a language problem. okay, if they only speak Portuguese or speak Spanish, or they've come from Italy or somewhere where they might have um, connections, greater connections to the community. The Mahamad know these people. They know how the economy of the community works. They know their own finances. So it really does make sense for these poor people to come to the Mahamad and ask them to handle these disputes, as opposed to going, for example, into the court of request. Does it answer?
Yes. Yeah, yes, thank you. Can I though inject a slight amount of cynicism to do with halakha, because this is a community that is led by merchants that is not always the most respectful about towards rabbis and their views, and it seems to me, and maybe this is perhaps due to being a member of that particular community, that it is more about dignitad and how the outside world will perceive the community, especially at a time when the permanence wasn't completely assured. And I wonder, for example, how it compares to the community in Amsterdam and indeed the contemporary Ashkenazi community.
So that's a fantastic question, and you're right to be cynical. However, I would argue that if you look at Amsterdam, and there is another academic called Evelyn Oliel Grouch, who's done work on the Amsterdam, the justice system of the Amsterdam community. You can track back from the original Ascamot of the London community back to the Amsterdam community. And you can track back from the Amsterdam community to Venice. You can also bring in Livorno, or you could bring in Hamburg. So I think that you can argue, when you open the lens out to so many of these Western Iberian communities, that they themselves must have valued settling disputes amongst themselves for reasons other than they were afraid of their position in the countries in which they found themselves. That there was something that was over and above simply the expediency of trying to keep what Alex Kerner has called their dirty linen inside of the communities. And also one has to remember that the Ashkenazim in the Council of Four Lands in Eastern Europe had very strong justice systems at the time. And there is cross-fertilization and there's cross-education between the communities. So it seems to me that it would be oversimplifying matters to say that there's purely an outward-facing reason for why the converters who come out in 1656 and articulate, their motivations in 1664 would only be thinking about their position in relation to the government, in relation to the City of London. Perhaps I'm less cynical.
Okay, thank you very much, Ton.
What means did the Jewish court have to enforce their decisions? I mean, they couldn't hand out bodily punishment or capital punishment.
Correct. And that's a superb question, particularly in relation to England. Because if you compare, for example, in Amsterdam, there was a system which the academic that I've mentioned calls embedded justice, whereby it was possible to have a decision of the Jewish court enforced as an arbitration award in the by the Amsterdam courts. There's nothing like that in London, and London is far more precarious for this issue of how do you get buy-in from the community. And my argument is that your buy-in rests on what I have called the interpretive commitments, to borrow another academic's word. You rely on people to comply with the system. And in the you really, really struggle to enforce both internally, and there is no enforcement externally. I found no evidence in my research that the English courts ever knew that the Mahamad Tribunal was operating as a dispute resolution process. There is, and this is another story, and we can have another seminar about it, there is excellent evidence in the ecclesiastical courts, the Christian courts, that they knew the Beit Din existed in the late 18th century, but not that there was the civil jurisdiction. So it's a huge problem, and you ask an excellent question. And perhaps that's also one of the reasons why, in the end, the system crumbles.
Thank you. I have a small remark. There was a slide that started with Yehidim, and under the Yehidim were the poor.
Yes.
In Amsterdam, Yehidim are members who pay Finta.
Correct. And in London as well. In London as well. It's they shouldn't really be there. But I think I was using Yehidim as a kind of a loose way of saying, people who are part of the community, who seem to be part of the community. But you're absolutely right. In strict terms, they're not.
In Amsterdam in the 19th century, they were called congregantes.
Okay. And actually, you see that that's a great point. I must remember that for my book, because you see that in Ascamot as well, that they start to use that word as well here in London.
It will be interesting to know at which point they start using that term. But before that, they simply did not have a term for that.
Yes. My recollection is the late 18th century, but I'd have to check it.
Yeah. Thank you. I see hands raised. Bruce.
Yeah, Wendy, listen, this is great. You're crossing so many thresholds of legal jurisprudence. It's kind of, way cool. Do you have an example of an inheritance case that was decided by a Mahamad or the batei, and how that inheritance, what the race, the property was that was being adjudicated? That was
off the top of my head,
sorry.
I can't give you a particular case, but there are inheritance cases. But I have to contextualize it for you. And that is that there's a wealth of evidence that the community was using English process for inheritance. So we have wills, English wills. There are inheritance disputes in English courts. So the interesting thing is to see that there's a possibility of an inheritance dispute being settled before the Mahamad, but also that this is one of the main centers of law where there's the use of different courts. Because after all, when money is passing, it's really important to be able to do that absolutely validly by the law of the land. Okay, and how are you best going to do that? By doing it in the courts of the land and by getting a court order, or by complying with English legal process, that you are writing a will that is valid in English law. There is, and I think it might be an article by Diamond on Sephardi wills. If you're interested in that, and if your email is passed to me, I can send you the article. But that's a really great question.
Yeah, thank you.
Ali?
Ali.
Oh, you're muted.
Yes.
Yes, there we go. Sorry, I just want to say that was absolutely fascinating and wonderful for me to listen to as well, because these are things I'm very interested in. But I have a couple of points. First of all, on the injunction against using non-Jewish courts, you've probably come across this very interesting case of a fellow called Joseph Uzeli. I don't know if
Yes.
you've heard of him. Julia Lieberman used his as a case history in one of her articles, and I also refer to him in my MA thesis a couple of years ago. But he was what was later called an incorrigible vagabond. And he took the Mahamad to the Lord Mayor's court, not once, but twice, against their specific instructions, because they refused to put him on the permanent pension roll. He lost both cases, but I mean, it was interesting that he did that. But I think probably as a direct result of that, in 1781, the Mahamad brought out a new Ascamot, saying that if anyone had summoned the Mahamad or the elders before any magistrate or court of justice to complain of failure to answer his petition or grant the charity required, or any other complaint against our government, they would be banned from receiving any kind of tzedakah. So that was obviously a huge sanction, that they couldn't imprison them, they couldn't banish them. Well, they could give them harem, but stopping them from getting benefits, that was a major sanction. So I just wanted to note that. The other thing is that I mean, the thing I find most fascinating about the Livro de Pleitos is that you can almost hear the voices of the litigants, especially the women, I think, which is so rare. In fact, so rare for any people who are poor. I don't know if you've kind of thought about that, or I'm sure you have, but what do you want to say about that?
Yes, it is. It's so we were talking offline, and I was saying that my main interest in these documents is from a legal theory and legal pluralism perspective, and for the cross-fertilization between the two legal systems, the Jewish legal system and the English legal system. And as a result of that, I did quite a bit of research on this question of the voice of the litigant. And I think it would be fair to summarize that academics are skeptical about whether court documents of whatever nature really do articulate the true voices of the litigants. And they're skeptical for a number of reasons. The first is that the procedural process overlays a dispute. A dispute is funneled through a procedural process. And so litigants have to comply with that. And oftentimes documents can have to comply as well with that procedural process. So here, although there are voices, I would argue, they're not terribly strong voices. There's no direct speech, okay? It's mediated through the person who is the record keeper. So should we really take at face value that what is recorded on the page is in fact what happened in the room? I think we have to be able to decode these disputes. And I think we can decode them by opening them up, by looking at the keywords. That's why I was looking at resolve or recommend, because those might be clues about, how active was the Mahamad in the courtroom? Okay, were they imposing something on the litigants? What might have been the conversations between the litigants? Likewise, if you situate a dispute within what could have happened in an English court, you might get an idea of what might have been said as well in that court. I'll give you another clue. There's a tiny reference to covered woman in one of these disputes. It's obviously you must have seen it in the English. And you can say, what the hell does that mean? Well, what it is question of the position of the married woman, that a married woman didn't have the right to litigate on her own behalf. She had to litigate in the name of her husband. So that gives you a clue, but it is a voice, but it's a faint voice, and it's a voice that you have to listen to and then think about and find a way of really understanding what might have been going on in that court. Does that answer your question?
Yes, thank you. Thank you very much. I have a couple more questions, but I'll let others go.
Okay, and thank you for talking about as well the sanctions, because I omitted that. You can definitely argue that the dakha was a very fierce weapon to enable the Mahamad to ensure that people were coming before them. And the 1781 incident is an excellent example, so thank you.
Arnold.
Hi, no. Hi. Arnold de Vries. Wendy, so very, very interesting. I've come across actually it is in an inheritance in a will to an ancestor of mine, and it deals with a family called Mendes da Costa, Hananel Mendes da Costa. Have you
Yes.
come across
Mendes
them?
da Costas are everywhere. Yes,
They're everywhere. Exactly. Yeah.
Yes.
I went to the archive of the Bank of England actually to look at this information, to look a bit further. And I just wondered if you'd come across it, and because I know it's much more than a straightforward question, but I was just interested what happened to this. This is 250 years ago, so I'm not expecting that there's any value there except for the knowledge of what happened to that. What happened to the family after that?
Well, there are many Mendes da Costa, but I mean, you're very welcome to email me at my email.
Okay.
And tell me more, and I'll think about it. But off the top of my head,
yeah,
I can't tell you whether I came across this particular person. But
okay.
Mendes da Costa is all over these documents.
Yes, I'm sure they are. Okay, they seem to have been very much involved in Amsterdam and in London. So
yes,
and my family is from Amsterdam, so
okay,
we just came. But yeah.
Okay.
Thank you very much. I will email you. Thank you.
Ali again.
Maybe Ali knows.
Sorry, I can't see any more raised hands, so I'm going to jump in. So the other thing that I noticed in certainly the first two books is that women get a really bum deal. There's all these disputes, and women come before the Mahamad and complain about their husbands beating them or abusing them verbally, or they leave the home, they abandon the house, and the Mahamad almost invariably says, you should make up and go back.
Live in peace is what
yeah.
they say. Yeah.
It's very patriarchal, and it's not unexpected, I suppose, but I just noticed that that's a particular feature.
I mean, I don't know if you've got more time on this call, but I'll very briefly try and contextualize. And I'm not speaking in defense of the Mahamad, but um, I think it's important, for example, in relation to the argument about voice of the litigant, to contextualize these family disputes between husband and wife in relation to the English legal system in family law in this period, which was just as patriarchal. So the Mahamad are not acting anywhere differently. The second really important point to make is that it's not until 1857 that there's a right to divorce in English law. And before that, you have only the right of judicial separation, which is a remedy obtained in the Christian ecclesiastical courts. And so this issue of what you do when a marriage breaks down is an fraught issue for English law generally, and a very painful issue, and an extraordinarily difficult issue for women. And you see different ways in which English legal process tries to mitigate that, but it remains a problem until 1857, when there is a right of divorce. It's a very fault-based system. There is a counter argument as well, which is that Jewish women actually had a benefit of halakha, which is that there was a possibility of divorce. And you do see that there are divorces. But it's fair to say that the Mahamad try and keep people together in a technical marriage for a great length of time. Now, family law historians argue that there is breakdown of a relationship goes through an entire process in English law. And I think that you can say the same in these documents as well. And there are some examples where eventually you see that the Mahamad simply has to accept that these people can't live together, and there has to be some financial mechanism by which they can live apart. And if you track that into the minutes of the Mahamad, you can also see the divorces happening. So it is, and it's an incredibly important question that you raise. And I found it very painful to read these documents. And it was very hard to be a woman in a broken marriage during this period.
No, thank you very much for the context. That explains a lot, actually. Yeah, I thought, yeah. The other point I wanted to raise, if it's okay, Ton and David, is I wonder if the breakdown of the Mahamad's role as an arbitration court in 1863, was it?
1868, the book stopped, although the last dispute is 1864.
So it sort of just occurs to me that the full emancipation of Jews in England took place in 1866, which is suspiciously close. So I wonder, I mean, not necessarily as a kind of causal mechanism, but sort of flowing together, as it were, in parallel, maybe kind of created the conditions where it was felt it was no longer necessary for the Mahamad to intervene in these sort of legal affairs when, people didn't have any further legal disabilities.
Well, they didn't have legal disability. Okay, it wasn't precise. There was no legal disability to litigate a dispute from the beginning. There's a whole story about the possibility of there being barriers for Jews to use the courts, but for various technical reasons that doesn't happen. Okay. But you raise an interesting point. I'd also add that 1866 is the appointment of Benjamin Artom as the Chacham of the community, and evidence of the professionalization of the Beit Din. It was in the doldrum from the 1820s onward, even to the extent that Rabbi Herschel, the chief rabbi of the Ashkenazi community, is called upon to assist in resolving matters during that period between Artom and the late 1820s. So I think that that's a possibility, that's an explanation. Another explanation from a legal perspective is that this is a period when you see the professionalization of and centralization of the English courts. All of these lay courts wither away by the 1860s, and the possibility of justice in a court of lay judges without the litigants having lawyers disappears. English law claims far more aspects of law for itself. Okay. Example, I just mentioned divorce. Divorce comes under the civil court system. It's no longer living in the ecclesiastical court system. So there's so many particular reasons why, but you may well be right that is one of the reasons why eventually, I think they just fell out of love with it. They didn't think that justice could be done in that way. I think they might have seen that justice had to be professionally done by lawyers according to articulated law that was applied in a professional court.
Yeah, I just think it might be also very interesting to look at the case of Holland, where you have the French Revolution and its effects on Holland, and the Brabantia Rebellion, and the Napoleonic era, when emancipation kind of happened like that. Whether the either the Bet Dins or the Mahamads in Amsterdam or The Hague also kind of lost their motivation in some ways
In
when that
Amsterdam,
happened.
in Amsterdam, you see that comparable books of Pleitos end in 1816. That's right after
Napoleon.
the end
That's
of
so
French
interesting.
occupation. And I think Ali has a point. Modern times were introduced in Holland much more revolutionary and much more as a rupture than
Yes,
in England. And in England,
that's a great word. That's important distinction, that there's a real rupture, whereas the English historical situation is very different. There's a long process.
it's still going on.
Yeah, still going on. Jews and English courts, it's still an issue.
Okay, I see there are no more questions, David. Shall we wrap it up?
I think so. And thank you, Wendy. That was absolutely brilliant. And hopefully you will return soon.
I'm glad you enjoyed. I certainly enjoyed. Thank you so much for having me.
Thank you, Wendy.
Okay, bye-bye now.
And we hope to see you all in 2 weeks' time. And a big thank you to our patrons who are here and who support us. And once again, thank you, Wendy.
Thank you. Bye-bye. Bye-bye.
See you.